On today's historic decision, including the court's reasoning and the ramifications of the ruling, we welcome Roy Herrera. He's a former assistant U.S. attorney and a partner at Herrera Arellano LLP. All right, Roy, we got you here because this is big. Were you surprised by this?
I was not surprised by the ruling. I think a lot of it was telegraphed during the argument that they had, several months ago. It was a 6-3 decision in which they decided that a president has some form of immunity, as you said, for official conduct. It's kind of an interesting case because they broke up the type of conduct that could be or could not be subject to immunity into 3 different kinds of buckets. The first is, and you quoted from it, this is conduct related to constitutional authority. So core constitutional authority enjoys absolute immunity. Then after that, it gets more complicated because then the analysis turns into, if it is official conduct, then there's a presumption of immunity. And then if it is unofficial conduct or private conduct, then there is no immunity at all. But then the real question is, what is official conduct versus what is unofficial conduct?
And that is the magic question. Things about pressuring state officials to change election, fake elector schemes, these sorts of things. Official or not official?
Well, the court didn't decide that today. What the court decided to do is essentially kick this back to a lower court to make what it said would be a fact-intensive inquiry into whether a particular type of conduct falls within one of those buckets. So what's next in the actual case itself is that it's going to go back to the lower court, to the district court judge, to do that analysis and go through the various types of conduct and decide whether it falls within an immunity, and then, of course, what kind of immunity.
And Roberts basically said that this has to always start there at the trial court now, correct? I mean, they're basically punting it back downstairs.
That's correct. They didn't create any sort of test today, or certainly no clear test today, on what kind of conduct falls within the various types. Again, it's going to go back to the trial court to decide. I think effectively this means there's not going to be a trial. I think we probably knew this already in that criminal prosecution at any point this year. We'll see sort of what the judge decides to go forward. The judge could decide to have some evidentiary hearings, for example, in the short term, but certainly we will not go forward with any kind of trial before the election.
Okay, so presumptive immunity, that means, again, you're leading with no here. That's basic. That is favoring the president, the executive.
Correct. So presumptive immunity, again, that would be official conduct that doesn't necessarily implicate core constitutional authority. The presumption is that you have the immunity, and it would be up to the prosecution, who would have the burden then to show that the presumption should be defeated, that it should be rebutted. And essentially, the prosecution would have to show that prosecuting the president for that type of conduct wouldn't interfere with him exercising his executive authority. Again, that's going to be a question that a judge is going to have to decide at the lowest court, but that the prosecutor is going to have to win on.
And we should mention Chief Justice Roberts said you can't have new administrations making claims about previous administrations because you're wind up getting tit for tat. That seemed to be the basis of his argument.
That's exactly right. Just from a logic perspective, I think the 6-3, the 6 in the majority, the reasoning for that is this idea that a president shouldn't be subject to any kind of political prosecution. So in other words, after a president were to leave office, if somebody disagreed with the decision that he made during office, he shouldn't be subject to criminal prosecution for that. Of course, the 3 in the dissent, the liberal justices in the dissent, had a completely opposite view. It was their view that essentially if you provide this kind of immunity to a president, they would now be above the law because there would be nothing that this person could be prosecuted for.
And we did a little bit of what Justice Sonia Sotomayor said, but she really went to town here. She said, if a president uses official powers in any way, immune. Orders Navy SEAL Team 6 to assassinate political rival, immune. Organizes military coup to hold on to power, immune. Does she have a point?
She might. I mean, this is what it gets back to, sort of the problem, which is we don't have an actual clear rule or test that the court has provided. So if you take, again, sort of an extension of what the majority is saying, if a court finds that particular conduct, encouraging a coup or assassinating a political rival, is somehow, again, either an extension of core constitutional authority or official conduct, then theoretically the president, or former president in that case, would enjoy immunity.
Yes, taking a bribe for a pardon. Immune.
Exactly. And under the court's test today, or the decision today, that would be absolutely immune.
Trump said today that he's completely exonerated regarding J6. Is he overstating that just a bit?
Probably a little bit. I mean, I think, again, we're going to go back to the trial court, and the trial court's going to go count by count and decide what is actually subject to immunity or not. There are some underlying conduct that is the subject of the criminal prosecution, for example, related to his conduct with the fake electors, where it's an open question, I think, at this point on whether that's official or unofficial conduct. If the lower court finds that that is unofficial conduct, then theoretically the president could be prosecuted for that. But of course, he's going to appeal that decision, and we're probably going to come back up.
And also, did I miss this? Because one of the original arguments was the president needed to be impeached and convicted in order to be charged. Was that anywhere in here at all?
It was, and if there was one thing that I would point to as a loss here for President Trump was actually in that section of the opinion, because the argument that he made essentially is that if he was impeached and then acquitted, then he couldn't be prosecuted for that underlying conduct. The Supreme Court disagreed with that. So being acquitted in an impeachment is not some sort of easy way out or get out of jail free card.
So communication with the Justice Department protected, communication with the Vice President protected, true? Is that where we are right now? That's official business.
Well, the first is definitely true because Justice Roberts said that in his majority opinion, that his communications with the acting Attorney General, with the Department of Justice is absolute immunity because it is, again, related to his core constitutional power. Something like, talking to the Vice President is something that I think is, again, an open question. The court wasn't completely clear on that. I think Roberts indicated that there would be a presumption of immunity in that case. But again, we go back to what is the test? How do you determine what defeats the presumption?
And a presumption of immunity, I would imagine, for tweets and speeches regarding January 6th.
Again, that is going to be that fact-intensive analysis that's going to have to be done at the lower courts.
This seems like a really, really big deal, like a landmark decision that will go down for the ages, or at least until we get a test to figure out where we're going. True? You agree with that?
I absolutely agree with that. It's a historic decision. It has massive implications for not only President Trump if he gets back into the Oval Office, but future presidents. I go back to sort of the Nixon era, prosecutions, and then of course his resignation as the last time we've seen something like this, where we have to really think about the power and extent of executive authority in America.
Well, and even that, this court says you resigned too soon.
That's true. That's true. And so all of this is a bit ironic that this decision comes out the week of 4th of July, our Independence Day from, our independence from England.
Last question on this. This took an awful long time for the Supreme Court to come down. Very last thing that they did, maybe that was by design, just to get out of town and not have to deal with the fallout, but it also delayed what is now further delayed this Trump trial. Raise any eyebrows there?
I think it has to. I mean, this was literally the last decision under this Supreme Court term. They obviously could have made this decision a long time ago. I don't think the facts were any different than they were a couple months ago. So obviously they decided to do that. And again, the trial court has indicated that they're going to take at least 3 months before any type of trial happens. So if you're just looking at the calendar today, leaving aside the fact that they have to do these various inquiries on what is subject to immunity or not, we'd still be many months away, I think, from an actual trial.
Yeah. Roy Herrera, good stuff. Good to have you here, too. Thank you for joining us.
Thank you.